testify for the state as to that ultimate question in terms of the reasonableness of the force. We also expect training officers from the Minneapolis Police Department to testify about how officers are trained in the Graham versus Connor factors, in the reasonableness of the use of force and MPD policy, and all of that I think is 100% fair game in the course of this trial. What I'm seeking to preclude here is that, again, in the course of the investigation of this case, there have been numerous interviews of every Minneapolis police officer who was at the scene, not necessarily involved in this incident, but they're the guys who do the crime scene log, they're the guys who hang up the tape, they're the guys who are simply there as a part of the investigation, and they were interviewed as a result of that investigation. Just to, their body cameras were reviewed, their interactions with civilians were reviewed, but by and large, all of these people, all of these Minneapolis police officers were asked specifically about their training and about their understand whether they had seen the footage, whether they had seen the body camera footage. And some officers, refused to answer that, or basically said they didn't remember those types of things. And other officers had comments both ways. What I don't ultimately, I don't think what we need is 18 Minneapolis police officers coming in here and giving different standards and different. It ultimately confuses the issue. That's what this motion is designed to prevent, is the guy who hung up the crime scene tape asking him not necessarily what his training and experience is, but the ultimate question of what would you have done differently, which I think is reaching a conclusion that others is best left for others.
Other than its experts and training officers, does the state intend to try and offer those opinions of the various street officers?
No, Your Honor. The state doesn't dispute that a police witness can't simply testify that he or she would have handled Floyd's arrest differently without laying the proper foundation for that testimony. And what I mean by proper foundation is explaining what MPD policy and training requires and how the arrest should have been handled pursuant to MPD policy and training. And it sounds like Mr. Nelson and I and the state are on the same page on this.
Yeah, because just because someone has received training and then in hindsight wants to give their opinion, that's not appropriate. You have experts on the training. For example, a training officer can talk about it because they have the expertise. But hindsight observations of, I just put up the crime tape, but let me tell you what I would think about, that's not going to be allowed. So to that extent, the defense motion is granted. This does not limit expert witnesses to talk about whether the use of force by Mr. Chauvin or other officers in the scene on Mr. Floyd was reasonable or not. So experts, and even the training officers, I think, qualify as experts as to whether or not that was an appropriate use of force according to how they train. That would be allowed. All right.
Thank you. Then, Your Honor, with respect to number 21, the defense is seeking an order precluding a witness named Genevieve Hansen, who is a Minneapolis firefighter who was present at the scene, from offering speculative testimony that her intervention would have saved his life or could have saved his life. Ultimately, Your Honor, while we certainly understand that Ms. Hansen has certain qualifications, she's a Minneapolis firefighter, she's certainly trained in things of CPR, she may have experience in various regards. However, in this particular incident, our position is that her testimony or her opining that had she been able to intervene would have saved her life is just simply too speculative. Certainly the cause of Mr. Floyd's death is of great controversy in this case, and while she may be certified to perform CPR, she is not a forensic pathologist, she is not a physician of any nature, and whether or not Mr. Floyd's death was preventable had she been able to intervene would simply be speculative.
Does the state intend on offering that specific narrow opinion that Ms. Hansen could have saved Mr. Floyd?
We don't intend to offer the opinion that Ms. Hansen could have saved Mr. Floyd. What we intend to offer is her belief at the time of the incident that if she intervened, she could have saved Mr. Floyd. And the reason why that's important is because the state intends to call Ms. Hansen to speak to what she saw on the scene through the lens of her own perception and to explain the comments she made to the officers and the actions that she took on the scene. And part of that opinion, as is true with any lay witness, is shaped by her own personal experience. And in Ms. Hansen's case, because she's a firefighter, she's handled many medical calls, including calls regarding individuals who are unconscious. And so when she got to the scene, she saw that Mr. Floyd was breathing, but his breathing was heavily labored. And so based on her own personal experiences, she immediately called for the officers to check Floyd's pulse, repeated that plea over and over, and soon asked them to begin chest compressions on Mr. Floyd. And so we're only offering her narrow belief that if she was able to intervene or if someone had intervened, they could have saved Mr. Floyd in order to explain her observations during the course of the incident. And that's classic Rule 701 testimony. It's based on her observations at the scene and her own personal experiences and personal knowledge. And it's helpful to the trier of fact to understand Ms. Hansen's testimony and to understand what Ms. Hansen was saying at the scene.
I'm going to grant the defense motion to this extent. Ms. Hansen can describe what she saw. She can describe her training and experience. She can describe what she felt was indications that Mr. Floyd was in medical distress. She can indicate that she thought that at that time she thought medical intervention should have been started, because these are the things that she always does in the field, I assume, as a firefighter. She goes to the scene, she sees somebody is in medical distress and ultimately are in need of medical intervention. So she can testify to all that, and that explains her testimony. But to get to the point to make a medical testimony that she actually could have saved him is a medical testimony that she does not have the expertise, since she does not know all the other factors that are going into that. But she can say almost everything right up to that. The opinion that I could have saved him is not a proper opinion for her to testify to, but everything up to that and why she thought medical intervention was required urgently because of what she saw is certainly permissible.
Agreed, Your Honor.
So that's the court's ruling.
So I think those are the three defense witnesses that motions that we intended to deal with today. There is the state motion number 4 that we also wanted, and perhaps, and I apologize to counsel for the state for not bringing this to your attention, but with respect to number 5 of the defense motions, which was the criminal background checks of potential jurors, I may have inadvertently stipulated to that. However, meaning that was work product. The rule, however, clearly establishes under Minnesota Rule of Criminal Procedure 901 that reports on prospective jurors are discoverable to the defense. So I would just note that.
Does the state have a response? I don't know who would like to respond to that. Anybody? Mr. Frank? Or?
No, Your Honor, we'll take a look at that and let you
All
know.
right, we'll return to that, but I'll be honest. When you stipulated to that yesterday, I was kind of puzzled because the rule specifically provides for it. So,
I think it was just because we were skipping around and with different motions and.
The rule does not require that the state do these checks, but if they have and they have the information, I think the rule provides, but I'll allow the state to revisit.
All right, if I may.
Sure, you don't have to, I'm not ruling at this point now, so if you want, you can wait.
I think we may have been addressing this motion in the broader sense of other information or background information.
Right.
That which, if we have this, would clearly be work product. I'll double check the rule, and if he's right, we'll let the court know.
All right, I appreciate that. All right, we'll reserve that until later when the state confirms what their position is. Is there anything else for this morning?
Number 4 of the state's motions, Your Honor.
All right. All right, who would like to argue that? Mr. Blackwell.
Good morning, Your Honor. So again, it's Jerry Blackwell for the state. Our motion number 4 is to exclude or limit any argument, evidence, or testimony regarding the MPD's decision in terminating Mr. Chauvin or the MPD's civil liability with respect to that lawsuit. And the reason and the context for this concern, we could see in the motion to dismiss for lack of probable cause, and this is the concern about it. As the court is well aware, the Minneapolis Police Department terminated Mr. Chauvin's employment on May 26th. And that may tell us quite a bit about what the Minneapolis Police Department thought of Mr. Chauvin's use of excessive force. But at the end of the day, that's an analysis and an assessment for the jury to conclude whether the use of force was objectively reasonable or not under all of the circumstances. The problem that with the defense raising the termination is what it brings along with it. And it brings with it, as the defense at least has used it, the likelihood of injecting either issues of race, either intentionally or that still being the impact, and or politics. And an example, Your Honor, so that I'm clear about what I mean, is that in the motion to dismiss the complaint for lack of probable cause, Mr. Chauvin suggested that the termination decision was based on community pressure and was rushed, and then later on said the chief fired him after talking to several local faith leaders from the African American community. Now, given the relatively slight probative value of this after the fact termination in the first place, and looking at all the baggage it brings with it for interjecting issues that could inflame the jury, frankly, whether that's intended or simply that's the impact of it, I think it's kind of hard to argue. But at the end of the day, the decision to terminate him after the fact doesn't really illuminate whether or not for the jurors the use of force at the time in question was objectively reasonable under all of the circumstances. And to interject that into the case in the framework of trying to introduce either politics or to throw in some reference to Chief Arredondo, who's African American, talking to African American faith leaders, is unnecessary and carries with it, in my view, too much of a risk of prejudice and interjecting an issue of race in the case when it's completely not necessary or warranted by the relatively slight probative value of this in the first place. And the same can be said with respect, Your Honor, to the MPD's civil liability lawsuit. It just doesn't have kind of much bearing on what the jury has to decide, and then brings with it too much baggage.
What does the state intend on offering regarding his termination? Anything?
No, Your Honor.
Even the fact that he was terminated?
If it would be only the fact that he was terminated on the 26th, and that's all.
All right. Mr. Nelson, you want to speak to that?
Thank you, Your Honor. Mr. Black.
I'm sorry.
That's okay. It's a brave new world for us all.
It is.
Your Honor, it's certainly not the defense's intent to interject race into this particular question, or why that evidence would be relevant. I think the court needs a little bit of background factually to this question, because I believe that this information would be relevant and admissible under Rule 616 of the Minnesota Rules of Evidence, the rule of bias. Bias is admissible. It is provable by extrinsic evidence. Ultimately, Your Honor, the Minneapolis Police Department is a law enforcement agency, and we are aware, I think those of us who work, again, within the criminal justice system, that the police department's simple job, their primary job in investigating criminal activity, is to gather facts, to gather evidence, to gather information, to then form a legal conclusion with the assistance of a prosecutorial agency in order to charge someone with a crime. This becomes highly relevant to the issue of bias because, again, Chief Arredondo was interviewed by agents Ryerson and Peterson, I believe, the Minnesota Bureau of Criminal Apprehension, slightly or shortly after this incident. Chief Arredondo explained that what happened was he was made aware of the critical incident. He checked the milestone cameras, went about the normal critical incident policy, and then was made aware of the citizen civilian Facebook video. He immediately recognized that this was going to have bad optics for the city of Minneapolis. He consulted with faith leaders. We don't have to involve, I believe actually there were probably additional faith leaders other than the African American community. He consulted with the mayor of the city of Minneapolis and made a decision within about 12 hours to terminate 4 Minneapolis police officers, 3 of whom he specifically states in that statement appeared to be acting consistently with training. So a decision to terminate someone based on an absence of evidence is probative of the chief's bias and concern about how the community would respond to this. So terminating him, terminating Mr. Chauvin and the other 3 officers involved is reflective of potential bias. Further, Your Honor, with respect to the civil lawsuit, certainly I think the court is aware, Mr. Floyd's family has filed a civil lawsuit. The city has made a Rule 68, a substantial Rule 68 offer, and the city acted in an effort to immediately, within hours, to attempt to limit its liability and distance themselves from this incident, whether it be for politics or whether it be simply to potentially mitigate financial exposure to the city. That is the very nature of bias. And if Chief Arredondo is going to be testifying, not necessarily every aspect of it, but certainly the underlying fact that he made this decision absent a full investigation or even a partial investigation. He made this decision based upon how he feared the community generally would react to this. That goes to bias, Your Honor.
Do we anticipate, I'll throw this out to anyone, do we anticipate that Chief Arredondo is going to be a witness?
All I can say, Your Honor, is that the state has met with him on at least 2 occasions in trial prep, so I would expect that he would be testifying.
Mr. Blackwell.
Your Honor, we do expect that Chief Arredondo is going to be a witness. And let me just comment on a couple of the points that were made by Mr. Nelson, because he had made a couple of factual assertions that we take tremendous issue with. And the first is that Chief Arredondo made this decision in the absence of any evidence. It was based upon obviously plenty of evidence in the video footage that Chief Arredondo was then able to see. We consider that evidence. And Chief Arredondo saw it. There will be 0 evidence in the case that Chief Arredondo went out to take a poll of faith leaders to decide what he was going to do. And if you look at the actual transcript, Chief Arredondo made his decision based on what he saw, based on his knowledge of what appropriate conduct was, and for him it just wasn't even close to the line when he made his decision. He informed the community of what he had decided. He wasn't asking them what he should do. And there's a big distinction.
Well, doesn't this demonstrate the rabbit hole we all go down when we start talking about the termination and the civil lawsuit and everything else? Let's take it out of the context of this case. If someone was charged with embezzling, not a public figure, their company fires them immediately, and the person is charged criminally, it certainly would not be admissible to say that they were fired by their company, because that's almost an offering an opinion, an implicit opinion, that they thought the person was guilty of a crime. So aside from the fact that all this was very public, the fact even of termination here seems to be inappropriate, because it essentially is implying an opinion by Chief Arredondo and the city of Minneapolis. The fact that they made a substantial offer and a Rule 68 offer, all of that seems to indicate we're just going to be chasing down, well, how extensive was it before he terminated? So if the parties are agreeable that it can be brought out that he is terminated on this date, that makes sense. But I think I'm not even sure why this should come into evidence at all. His employment status seems to be a different situation, and it could imply a conclusion that he was guilty of a crime, when it could have been a variety of reasons why he was terminated or why the state is making an offer. I guess, so I throw that out to you. What are your thoughts?
Judge Cahill, it may have, I think, some probative value in simply framing his employment tenure with the police department. He started on X date, employment ended on X date. And whether it's ended by virtue of termination or however it's characterized, it just gives you the two hash marks of when he started, now when he finished.
Let me turn to Mr. Nelson. You can stay there. What about that? That's saying that Mr. Chauvin started on this date and ended his employment with Minneapolis on that date. Not terminated, ended his employment. Would the defense have a problem with that? Because I think that is relevant.
We don't have an objection to that, Your Honor.
Because that does not imply an opinion by the city of Minneapolis, although it may have been stated publicly, that would come into evidence in this case. And that's my concern, because in a normal case, we wouldn't even get close to talking about whether a person's still employed by their victim employer. So why, I guess, that's what I'm throwing out. I think I am going to rule in that manner, which is the state can bring out the dates of employment, and he is no longer employed by Minneapolis Police Department.
Thank you, Judge.
We avoid all this problem of why did Judge or Chief Arredondo terminate, all that kind of stuff. And it's very limited probative value, but I think you get it with what I have now stated the state will be allowed to do. Mm-hmm. Any questions about the limits on that?
Nope, understood, Your Honor.
All right, thank you. Do we have any other motions for this morning before we start jury selection? Or any updates from the Court of Appeals? As Mr. Frank checks his phone. Yeah, you can all check your phones if you'd like, just to see where we're at.
Nothing, Your Honor, sorry.
All right. Any other motions for this morning, though?
No, we got through those a lot faster than I think we anticipated, Your Honor.
Well, you all cut right to the chase and went right to the heart of the matter, which is appreciated by the court. All right, we're going to stand in recess then until our jurors are ready at 9 o'clock. Do we know how many we have?
Do you want me to check and see if number one's here?
We have to do the full advisory. We're going to start with the full group in the courtroom, where I'll essentially introduce them to the parties. So, and I turn to counsel. Do you wish to have me just introduce you, or do you wish to introduce yourselves to the jury?
Your Honor, coming out of the state, I prefer to introduce myself.
All right, let's do that. You can all introduce yourself. I'll turn it to you specifically to introduce yourselves to the jury. All right, anything else?
Nothing, Your Honor.
All right, we're in recess until 9 a.m.